glued the top off of it, and then this gentleman who's a tech, he was like, I mean, he was kind of like the first on the science side.
Can this just stays here?
It can stay here.
Okay.
I'll actually turn it on in case it's not on until it turns green.
There we go. Beautiful.
And it'll catch a lot of ambient
Oh
noise.
yeah.
Okay.
And if you need to, huge deal for
Okay.
university.
Thank you very much.
But it's just so tragic.
Okay.
Insanely tragic, and it's mostly low-income people of color, and now their houses, which in many cases are like the one asset they have or investment they have, are worth nothing. I mean, it's not like you can just like pack up your bags and move. No one's gonna buy your house.
We have a colleague in Blacksburg who here you're talking to you, and she's not been feeling well, so she's
Okay.
make sure that
Nice.
on the whole we do, but So thank you all for coming. I'm Susan Steer, and I'm a professor in the Center for Public Administration Policy. And this is the last for the year in our series of talks with Metropolitan Institute, sponsoring with the School for Public and International Affairs. And I'm delighted to be able to introduce Professor Sandra Levitsky, who is visiting guest from the University of Michigan, where she's an assistant professor of sociology as well as director of undergraduate studies, right?
Correct.
Didn't somebody talk to them?
I know.
We're not supposed to do that with professors. So, anyway, Professor Levitsky is the author of Caring for Our Own, which concerns long-term care work in the United States and why we don't imagine social welfare rights in this country. And there's a big literature in political science now. I don't find the political science borrows enough from sociology, so I really want to emphasize that. A big literature in political science now on policy feedback and how what we know from our policies might shape what else we want or what else we know. And her book is directly on point about how the structure of our existing policies shapes what we can even imagine is possible. Her subsequent, and that book was out 2014?
Mm-hmm.
Okay, out of Oxford University.
Mhm.
Yeah. And she's also edited a book on social movements in American healthcare. Her current project concerns childcare, which she says is a happier story than long-term care.
Just a little bit
Which is
happier.
a little bit happier, which is good in terms of needs for preschool in the United States. But today she's talking about law versus policy, why, or the problems with socio-legal studies, law and society studies, having largely abandoned the study of social welfare rights to sociology and then also to public policy studies, which I think is your big focus. And what might have been lost and how we might recover that. So it's really productive for building a field that I'm really interested in and part of. So thank you, Cindy, for coming.
Thank you so much. So, as Susan mentioned, I come to you today from the great state of Michigan, where water is on our minds a lot these days. Michigan is surrounded by the largest group of freshwater lakes on the planet, and yet we are confronting some of the gravest crises involving access to fresh water, to drinking water, this country has seen in a very, very long time. So the city of Detroit for a couple of years has been terminating water service to tens of thousands of households who cannot afford to pay their water bills. And then, as most of you know, the city of Flint more recently has poisoned thousands of households with lead-contaminated water. And we hear in the news a lot about water as a casualty of weak regulation or water as a casualty of bad decision making. Today, I want to suggest that water is also a casualty of our disciplinary imaginations. Why don't public policy and socio-legal scholars study water as a socioeconomic right here in the United States? This used to be the calling card of socio-legal studies, the study of social welfare. And what I want to talk about a little bit today is how in the 1970s we gave up the systematic study of issues like health and food and water and poverty and education to the field of public policy. And the field of public policy took up those issues with relish, but very rarely studied these issues through the lens of law and rights. And neither discipline actually studies the relationship between law and social welfare. And neither discipline really considers what might be gained from having that theory. So today I want to offer a little bit of an intellectual history that seeks to locate this gap between the two fields of public policy and law, and kind of offer a bridge between them. And I come here as a socio-legal scholar, so I'm trained in both law and sociology, and my work tends to shade into the world of public policy. So I often find myself staring down this gap in the fields. And I wonder how it is in particular that socio-legal studies, which was this subfield that started in the 1960s with an eclectic group of lefty lawyers and social scientists, how it is that this community would stop studying issues of social welfare distribution. The socio-legal community has this endearing tendency to think of ourselves as a really big tent, right? So we welcome all disciplines, we welcome all methodologies, we embrace all schools of thought, and we like to count absolutely everything as law. We count court decisions and administrative regulations and statutory law and informal norms. Law is all over according to our marketing materials. And yet in one critical respect, this actually is not true, that we have not been studying for a very long time issues of social welfare distribution, and neither has public policy through the lens of law. So I'm going to start off today by providing some empirical evidence for my claim that socio-legal scholars are averse to studying welfare distribution, and talk about why we have placed these types of laws outside the scope of the field. And I focus on this side of the equation in particular because it is this body of scholarship where we would expect research more than any other place on the relationship between law and social welfare. And then I want to talk about how we could conceptualize a theory of the relationship between law and social welfare, and socioeconomic rights in particular. And I'm going to illustrate that by bringing us back to the case of water. So how did an issue like water move outside the boundaries of socio-legal scholarship and relocate to public policy? So I want to draw on some data today that I collected with my colleagues Rachel Best and Jessica Garrick at the University of Michigan. And this is from a study that seeks to track variation over time in what types of issues have been understood as subjects appropriate for socio-legal analysis. And to do this, we combined a quantitative analysis of articles published in the field's flagship journal, the Law and Society Review, and we combined that with a historical study of the emergence of the fields of public policy and socio-legal studies. Our quantitative analysis relies on a representative sample of LSR articles. So we began by randomly sampling half of all the empirical articles that have been published since the journal's founding in 1966 through the fall of 2014. And since our argument relies very heavily on the very early years of the Law and Society community, we sampled all articles from the journal's early years, published from 66 to 72. So the result is a sample of 550 articles representative of all empirical work published in the Law and Society Review from 66 to 2014. And I'm not going to bore you with how we coded these, but we were coding these articles based on abstracts, and I'm just going to mention two things about this process. So first, we were looking to see how many of these articles focused on distributive laws. Okay, so these are laws that primarily distribute or redistribute resources, benefits, and or services, as opposed to laws that simply regulate behavior of people or behavior of organizations. Now, we recognize that regulation and distribution are not mutually exclusive, right? But we argue that most laws can be classified as primarily one or the other. Regulatory laws almost always have distributory consequences in the long term, but they do not instruct the government to distribute resources directly. And while distributive laws always include some regulations, their main objective is to distribute resources, right? So in the area of employment law, for example, the Family Medical Leave Act certainly has distributive consequences, but its main objective is to institute requirements that employers must follow. So we classify that as regulatory. By contrast, Social Security disability insurance involves some regulation of individual behavior, but its main objective is to distribute benefits, right? So we classify that as distributive. The second thing that we coded for was the substantive area of law. So we broke this down into 12 areas: workplace, health, housing, education, welfare, taxes, budgets, other socioeconomic issues, environment, immigration, foreign policy and international law, and then the big areas of criminal and civil law. And these codes were not mutually exclusive, so articles can refer to multiple substantive areas. And for purposes of this analysis, we combine the first 6 types of law into this broader category of social welfare and economic laws. So these are laws that involve primarily human welfare or economic issues. Okay, so what did we find? We found that despite our claims to being a big tent, the scholarship published in the Law and Society Review has focused on a very, very narrow range of issues. The overwhelming majority of articles published in this flagship journal focus on laws that regulate behavior, okay? Fewer than 3% of articles focus on laws that distribute resources. And we argue that this virtual absence of distributive law in this subfield suggests they have been defined as sort of outside the scope of sociolegal research. Looking more specifically at substantive areas of law, we found that articles on social welfare and economic laws are also rare but not entirely absent. So 15% of articles address social welfare or economic laws. But I want to emphasize that when authors do focus on these types of laws, they rarely study how these laws distribute resources. So for example, Cal Morrill and his colleagues wrote a fantastic 2010 article that focuses on youth perceptions and responses to rights violations in schools. Okay, so this article focuses on education, which is a social welfare law, so social welfare policy, but the focus is on rights perceptions in schools and not the distribution of education resources. Okay. So less than 2% of articles in our sample focus on social welfare or economic laws from a distributive perspective. Now, what is so striking about these findings is that it hasn't always been this way. Okay, so in the late 1960s, when the field of sociolegal studies first emerges, scholars are embracing a wide range of topics, including distributive laws and social welfare and economic laws. In the 50s and early 60s, the environment for doing research on social welfare was really, really different, right? So this was the time of the expansion of the American welfare state, an active and left-leaning court system. There was a lot of research from foundations and the government that all sort of encouraged this focus on sociolegal, on state distribution. So the 1960s was probably our most defining moment in terms of welfare state expansion. This was the time when President Johnson's Great Society programs were proliferating. It was a very ambitious attempt to try to use government to solve these wide-ranging problems like poverty and racism and urban unrest. And key to this expansion was a really pervasive faith in the social sciences, right, as tools for improving the efficiency and the effectiveness of government. Right? This was the heyday of policy analysis, when this field was really coming into its own. And it was a time when there was private and public money coming in for policy analysis that helped to refine policy theory, methodology, research design, and all of these developments fed into the rising allure of the social sciences as a key component of welfare state expansion. The 1960s were also a time of a tremendous expansion in judicial responsibility. So when courts were involved in making decisions about social welfare that would have once been considered unfit for adjudication. So they became involved in things like welfare administration and prison administration and mental hospital administration, automotive safety, natural resources management. And this was also a time when judicial action involved requiring other branches of government to expend public resources of such magnitude that it influenced the setting of public priorities. So courts were forcing school districts to bus kids across cities in order to achieve racial balance. They were compelling industries to adopt new methods of controlling pollution or preventing accidents. They were requiring states and localities to provide free defense attorneys for poor criminal defendants. And then this was also a time when foundations were investing in projects that sought to sort of bring sociological, social science expertise to law and to bring social science-informed law to the activist state. Okay, so in the 1960s, policymakers were drawing on social science and administering these new social welfare laws. The courts were expanding state provision. Foundations were encouraging this connection between social problems, law, and social science. These were really fertile conditions for scholars to be studying distributive laws, and this emerging field of sociolegal studies took up that charge. The Law and Society Association was founded by a group of law professors and social scientists in 1964. Its flagship journal began publishing 2 years later. And early research in this time focused very heavily on distributive laws. In the first few years, more than a quarter of the articles published focused on social welfare and economic laws. About 1/8 were emphasizing distributive laws. So the journal was publishing articles on school desegregation, urban renewal programs, community action programs, Head Start, all considered important subjects for sociolegal analysis. And then the 1970s arrived. And the 1970s brought the defeat in Vietnam. It brought high rates of crime and urban unrest. It brought a failed war on poverty and the resignation of a twice-elected president. And these events shaped not only how Americans viewed their government, this is where the cynicism begins to kick in, but also how they understood the role that social science should play in informing government policy. So if the judicial branch briefly seemed receptive to the possibilities of achieving progressive social reform through law, that optimism gave way in the face of this pretty sharp conservative backlash. The 70s began a period of about 4 decades of conservative appointments to the federal courts, a very sharp constraint on the political activities of the Legal Services Corporation. This is when we start to see this conservative discourse pervade American politics that encouraged Americans to believe that inequality is the product of bad individual choices rather than social structures, that government is the problem with our country today, not the solution. And this all culminates in the Supreme Court's refusal to recognize a right to welfare or housing or any form of socioeconomic right short of a limited right to education. So after 1970, published research on issues involving state economic distribution dramatically declined. So the distributive laws are the dotted line. I should note this is a 5-year moving average. So our sample includes 0 LSR articles about distributive laws from 1971 to 1974. And the percent of articles studying distributive laws never exceeds 4% for the next 4 decades. Articles about social welfare and economic laws also dropped precipitously from 30% in the late 1960s to just 8% in the 1970s. Public policy, meanwhile, was in the midst of its own disciplinary transformation and found itself very well positioned to embrace these issues that sociolegal scholars were sort of casting away from the purview of our analysis. So in the 1970s, the Ford Foundation provides multi-million-dollar grants to 8 new programs developing graduate programs in something called public policy. And the key innovation of these programs was to shift away from pure policy analysis to a focus on problem-centered research with an increasing emphasis on normative prescriptions. And so those issues that the legal academy no longer viewed as appropriate for legal analysis, like water and sanitation and housing and poverty and health and work and social security, all of these become incorporated into a now distinct and virtually non-overlapping field of public policy. I should note that starting in the 1990s, some sociolegal scholars returned to the study of social welfare and economic laws, but importantly not from a distributive perspective. So we see studies relating to welfare and education and healthcare, but these articles are mostly about legal reasoning, legal disputing, bargaining in the context of health context or education context, and not laws governing the distribution of resources. So in this way, LSR articles begin to address social welfare and economic policies again, and that change is fairly dramatic. So it goes from 7% from the 70s to the mid-80s to about 18% since 1986. But again, these articles lack a distributive focus. All right, so as welfare state expansion drops off the policy agenda, and as the doctrinal basis for socioeconomic rights just unravels in the 1970s, sociolegal scholarship abandons its focus on distributive law. And the question is why, right? Why would a sharp decline in what's going on in the legislature, legislative support and judicial support, lead to a parallel decline in scholarship about such laws? So here we argue that the sociolegal field, very much like the public policy field, lacks a social theory that would illuminate the relationship between law and social welfare. And as a result, when legal and political support for social welfare laws unravels in the early 1970s, scholars did not have the conceptual tools they needed for studying law's role in creating and reinforcing economic inequality. So scholarship in both fields, sociolegal studies and public policy, studies law in action. Right? It seeks out and analyzes law in action, but it depends on its counterpart, law in the books, as a point of departure. And in studying the gap between what laws say and what laws do, we implicitly legitimate official law or state law as the appropriate yardstick for measuring success. So on the topic of poverty, for example, sociolegal scholars have studied the way in which the legal experiences of the poor differ from the non-poor. But very few scholars have explored the law's role in the persistence of poverty over time, or the responsibility of law in creating cultural categories of deservedness when it comes to state provision. Very few studies have explored law's role in creating property or value. The distribution of wealth in our country depends, after all, on a state-created system of legal rights and obligations. But because our point of departure has always been this aspiration of improving existing law rather than transforming it, we rarely ask questions that challenge the perspective of policymakers or legal elites. And in the absence of a theory about the relationship between law and social welfare, we have no response when the courts, for example, deny the legal existence of socioeconomic rights. Right? So when the courts refused in the late 60s or early 70s to accept issues of housing, health, or welfare as social welfare needs that the government is obligated to protect, they declared those issues to be non-legal, right? Or in the language of liberal legalism, they declared them to be political issues, not legal issues. And scholars never had the tools to contest that characterization. In the contemporary period, what needs to be explained is not a gap between what laws say and what they do, but the role that law's absence or the role that law's invisibility plays in constructing and preserving economic inequality. Right? So conceptualizing law's relationship to inequality involves three empirical or theoretical tasks: making visible the hidden role of law in structuring economic distribution, politicizing those dimensions of economic structures that are naturalized through law, and then analyzing the distributional effects of law with reference to some theory of social justice. And while there are a lot of different avenues for pursuing these tasks, I want to talk about the concept of socioeconomic rights as one path for understanding law's relationship to social welfare. And by socioeconomic rights, I'm simply referring to rights that seek to secure a basic quality of life for all members of society. Other countries throughout the world have now recognized socioeconomic rights to housing, education, food, water, work, health, social security. But American judges and American politicians and the American public have long rejected the idea that these kinds of rights apply on American soil. And the United States has ratified relatively few human rights treaties. And as I mentioned, the Supreme Court recognizes no explicit economic or social rights, with the exception of a limited right to education. Now, that Americans are so skeptical of socioeconomic rights represents a really striking historical shift. Because it wasn't that long ago, relatively speaking, that President Franklin Roosevelt introduced to the country this idea of a second economic Bill of Rights, right? A Bill of Rights that would guarantee Americans rights to jobs and adequate pay and fair and safe housing conditions and basic health care and Social Security and education. So in 1941, Roosevelt's administration was fresh from its experience with the New Deal and staving off the most protracted economic crisis this country had ever experienced. And it was confronting the rise of fascism and the onset of World War II. And in that context, Roosevelt concluded that there was a really important connection between individual insecurity and international conflict. In his 1941 State of the Union address, Roosevelt first articulated the 4 freedoms that he believed everybody everywhere ought to enjoy: the freedom of speech, freedom of religion, freedom from fear, and freedom from want. And then 3 years later, in his 1944 State of the Union address, Roosevelt emphasized the equal importance of traditional rights to liberty and economic and social rights. And he said to the nation, "We have come to a clear realization of the fact that true individual freedom cannot exist without economic security and independence. Necessitous men are not free men. People who are hungry and out of a job are the stuff of which dictatorships are made. Liberty," Roosevelt emphasized, "cannot exist in the presence of poverty." From this idea, and with the horrors of Nazi genocide still fresh in the world's mind, the international human rights system was born. The United Nations Commission on Human Rights articulated the first set of human rights standards in the 1948 Universal Declaration of Human Rights. And this was a series of moral, if not legal, entitlements to civil, political, economic, and social rights, meant to realize and protect human dignity. These aspirational principles, caught in the headwinds of the Cold War, were ultimately formalized in 2 distinct international covenants: the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, both enacted in 1966. The United States signed and ratified the former, but never ratified the latter. And instead, the United States sought to become the standard bearer of civil and political rights around the world. Now, today, some observers have recently taken the radical position that the real battles over civil and political rights in this country have mostly been won. So yes, we still have disputes about violations of those rights. And yes, we may still debate the scope of those rights. But the question of their universal importance and the need to defend them has now largely been settled. The new frontier is socioeconomic rights. What has become increasingly clear over the years is that civil and political rights are insufficient for addressing the kinds of deep inequalities that lay at the foundation of this society. We have been unable to move beyond the elimination of simple prejudice, for example, to consider such things as institutionalized racism or sexism or the striking dimensions of class-based inequality. So we saw this vividly in the context of Hurricane Katrina back in 2005. Right, the government's abandonment of thousands of people who were too poor to flee the city, and the hunger and the thirst and the chaos that those New Orleans experienced in the days and weeks after the storm shocked people around the world. But what was most striking was the fact that survivors of Hurricane Katrina were initially unable to articulate the injustice of their treatment under existing U.S. law. And we are witnessing the same thing today in the city of Flint, Michigan. So how would the concept of socioeconomic rights help us to understand law's relationship to social welfare? First, the concept of socioeconomic rights helps us to make visible the hidden role of the law in structuring economic distribution. We know, as social scientists, for example, that the distribution of wealth in this country is not simply the product of hard work, right, but a system of legal rights and obligations. Homeless people lack a place to live not because of lazy dispositions, but because someone has invoked and enforced the rules of property to evict them. right? Economic inequality is not a natural or inevitable state of affairs, but the product of legal rules. So the concept of socioeconomic rights trains our analytical lens on the role of law in distributing that which is necessary for a dignified human life: housing, access to food and water, adequate health and safety. Our society answers questions of who gets what and how much through the discourse of law, right? With rules about property and contract and labels like corporate person and employee and bankruptcy, and dichotomies like insured and uninsured, or exempt and not exempt, or permanent and contingent, right? These concepts are not only central to our economy, but they have profound consequences for the distribution of resources in our society. But once we recognize that there are legal rules that underpin the distribution of resources, we have to also recognize that these rules are not natural or inevitable ways of structuring distribution, but they are objects of political contestation, right? Law has a remarkable way of reifying the role of the state in structuring distribution. So the second task for socio-legal and public policy scholars is to illuminate the political dimensions of the legal rules of distribution. The power of the state to give to some and take away from others is not a neutral or impartial stance. It is a political choice about who shall enjoy property and who shall not. And those choices are not based on esoteric legal principles, but on values, right? Values about autonomy and individualism and equality and social justice. So the history of property relations in the United States offers many, many examples of the shifting role of values in shaping our understanding of property rights. The institution of slavery, for example, was created by the American property law system. Right? Slavery is a form of private property, and protection of property was one of the chief goals of the US Constitution. Today, we consider slavery to be an unacceptable form of property, not because of any changes in the institution of property itself, but because slavery contradicts basic values of human dignity and equality that we hold dear. Similarly, it used to be the case up until relatively recently that there were limits placed on the power of married women to own and manage property in their own right. Today, Americans view gender-based restrictions on property rights as contradicting values of autonomy and equality. So property rights at their core embody how we as a society have chosen to allocate finite and critical resources. They are, as Underkliffler-Freund recently observed, collective, enforced, even violent decisions about who shall enjoy the privileges and resources of this society. And this is the cruel paradox of property rights. Right? Property rights involve things that we need for human life, right? That we require for human life, but at the same time, granting a property right to one person simultaneously denies that right to others. And in a society of relative affluence, it's very easy to forget that connection between property claims and the necessary conditions for survival. But for millions, that struggle is very real. Legal theorist Robert Hale illustrated this vividly about a century ago with the example of somebody who wants to eat but cannot afford to buy food. There is no law against eating in the abstract, Hale observed, but there is a law which forbids him to eat any of the food that actually exists in the community. And that law is the law of property. Right? Law makes the difference between the availability of food and an entitlement to eat it. As Amartya Sen put it much more recently, starvation deaths reflect legality with a vengeance. So the third and final task for scholars interested in this relationship between law and social welfare is to articulate some theory of a just society, or to facilitate discussion about a just society. To treat legal rules of distribution as political objects, right? To consider them in the full light of public policy concerns and social ethics, is to analyze law in action, not against law in the books, but against some vision of a just society. How do we want our scarce resources to be distributed, right? What would be fair? How do we decide the difficult distributional dilemmas associated with recognizing an economic entitlement, right? A right that is conditional upon finite resources. If we were to recognize a right to health care in the United States, for example, What forms of health care would we be obligated to provide, right? What is an adequate minimal level of care? How much can society afford to pay for health care before other benefits or rights become compromised? Now, these kinds of questions are typically answered through normative argument, right? Debating competing social visions about morality and policy. But in the United States, these debates are typically stymied by a set of a priori assumptions about socioeconomic rights and our institutional capacity to protect them. So the first assumption is that socioeconomic rights are just too damn expensive to have in the United States. The second assumption is that there is a simple dyadic relationship between citizens and the state with regard to socioeconomic rights. And the third assumption is that courts cannot legitimately enforce socioeconomic rights. Rather than treat these assumptions as reasons to avoid political discussion about how to distribute resources in this country in a just way, sociolegal and public policy scholars could facilitate these discussions by studying these assumptions empirically. So take, for example, the assumption that socioeconomic rights are too expensive to recognize in a place like the United States. Right? They do involve highly contested budgetary allocations. But a number of scholars have observed that civil and political rights are also very costly to enforce. Right? But they are so routine, they are so embedded in our day-to-day existence that we don't notice those costs. Right? So a court system with judges and clerks and courtrooms and lawyers and a criminal justice system with prisons and police and parole officers are all so naturalized in this country, we rarely treat the costs associated with these systems as the costs of administering civil and political rights. It is only when the infrastructure for enforcing civil and political rights is absent that these taken for granted costs are clearly seen. So if you were to travel to Angola, for example, where there is no functioning court system and there is a chronic shortage of attorneys, you would find that all rights are virtually unenforceable, not just socioeconomic rights. Commitments to all rights require budgetary allocations. Right? So the question is, can we conceptualize a world where government guarantees of socioeconomic rights are so taken for granted that we don't even notice them as costs worth justifying? Second assumption about socioeconomic rights that warrants critical analysis is the idea that there is a simple dyadic relationship between citizens and the state with regard to socioeconomic rights. That citizens have a right to certain goods and services, and the state has the responsibility to provide them. And this is the assumption that often damns claims to socioeconomic rights to these caricatures of big government and the perils of direct provision. But missing from these accounts is the role of third-party providers. Right? So those parties that actually render essential social goods and services to beneficiaries: doctors, nurses, pharmaceutical companies, insurers, teachers, textbook publishers, landlords, builders. These private actors often control resources that directly affect the production and distribution of socioeconomic goods and services. And evidence from countries that have already recognized socioeconomic rights, like Brazil and India and Indonesia and Nigeria and South Africa, suggests that courts routinely seek to enforce socioeconomic rights for a much broader set of actors than the state alone. And in fact, legal claims requesting direct state provision are a minority of the cases involving socioeconomic rights in these countries. So in the face of this kind of evidence, we need more nuanced models of the classes of duties and responsibilities associated with socioeconomic rights. And then the third assumption about socioeconomic rights that is ripe for empirical challenge deals directly with the role of the courts. The assumption is that because socioeconomic rights involve the allocation of scarce resources, enforcement by judges would seem to violate the doctrine of separation of powers. Right? So can unelected courts mandate goods and services that are not provided by democratically elected branches of government? And here, too, there is evidence from developing countries that courts can and do enforce social and economic rights in ways that do not threaten democratic legitimacy and do not strain their institutional capacity. But consider an example from closer to home, the great state of New Jersey. The federal government, as I mentioned, grants very few socioeconomic rights to its citizens, but all 50 state constitutions guarantee a right to education. And New Jersey's constitution promises all New Jersey kids a thorough and efficient education. Now, New Jersey, for those of you who don't know, has maintained some of the most notoriously awful schools in some of the poorest urban districts in the country. And in 1981, education reformers sought to make the state live up to its Constitution's promises by filing a lawsuit, Abbott versus Burke, arguably the most important education litigation campaign for poor and minority kids since Brown versus Board of Education. So Abbott versus Burke stretched over a period of 3 decades and involved something like 20 decisions by the state Supreme Court. But the landmark 1998 Abbott decision required the implementation of a full-day public preschool for every 3- and 4-year-old child in every low-income school district in the state. So for all practical purposes, the New Jersey Supreme Court extended the right to education for the first time in American history to 4-year-olds and 3-year-olds, and forced the legislature to come up with a way for paying this dramatic expansion in state provision. So this decades-long battle not only produced one of the most accessible and high-quality public preschool programs in the country, but it offers a really compelling example of the expansion of socioeconomic rights by the judiciary. And cases like this suggest that our assumptions about what courts could do in the area of socioeconomic rights require some critical reevaluation. So what could the study of socioeconomic rights add to discussions of economic inequality? Here I want to bring us back to the subject of water, and in particular, a water dispute that has received less publicity than Flint, but which is no less striking in its implications. As many of you know, the city of Detroit filed the largest municipal bankruptcy in American history in the summer of 2013. And one of the many, many contributing factors to Detroit's disastrous city finances was the Department of Water and Sewage Department, which was $6 billion in debt at the time of bankruptcy. About $90 million of that debt could be traced to uncollected bills. And in March of 2014, the city began an aggressive water shutoff campaign to collect unpaid bills from individual consumers, terminating water to more than 27,000 households in Detroit. Now, for those of you who don't know, 40% of Detroit residents live below the federal poverty line. Residents have seen their water bills go up by about 120% over the past decade. Most of the people who are experiencing water shutoffs are African American, and 2/3 are families with children. When the water shutoffs began, residents mobilized. There were about a half dozen Detroit groups who organized protests, which the media covered and covered pretty well. This led to a 10-day hiatus in service terminations to allow people who were at risk of service termination to make payment arrangements. And the city during this time also developed a fabulous 10-point plan intended to improve customer service. And then the hiatus ended, and the shutoffs continued. When protests didn't work, advocates initiated a lawsuit against the city of Detroit. And the lawsuit claimed that the mass residential water shutoff campaign violated, among other things, the due process and equal protection clauses of the U.S. Constitution, and that it created a public health crisis. And then after a 2-day hearing, the bankruptcy judge found that the relief sought by the plaintiffs was beyond the scope of the bankruptcy court, and that their constitutional claims were deficient as a matter of law, ruling that there is no right or law to guaranteed water service. The judge noted that halting the shutoffs would jeopardize water department revenue at a time when Detroit was struggling to emerge from bankruptcy. Faced with no other alternative, citizen groups next sent an open letter to the United Nations asking for intervention. And the United Nations sent 2 experts on water and housing to Detroit. Those residents concluded that the failure to provide financial assistance for those who cannot afford to pay for water amounts to a human rights violation. They said in a statement that made headlines around the world, disconnections due to non-payment are only permissible if it can be shown that the resident is able to pay but is not paying. When there is genuine inability to pay, human rights simply forbids disconnection. The UN officials continued by saying that they were deeply disturbed to observe the indignity people have faced and continue to live with in one of the wealthiest countries in the world and in a city that was once a symbol of America's prosperity. Now, while the press attention that accompanied the UN visit was embarrassing to the city, it did not immediately stop the water shutoffs. And the mayor of Detroit eventually announced a new payment plan for people who were in danger of water service termination, and again temporarily suspended the shutoffs. Last March, a review found that there were 25,000 households on this payment plan, and in a mark of that plan's striking inadequacies, 300 households out of that 25,000 were actually current on their bills. Every other household was 2 months behind. So last summer, water service terminations for another 18,000 households began. So there is no legal right to water in the United States. Right? This is a jurisprudential fact. But conceptualizing water as a socioeconomic right helps us to make visible the roots of the Detroit water crisis. Right? There are legal rules that establish water as a commodity, right? Something to be purchased, or if one cannot afford it, something to be withheld. But just as critically, conceptualizing water as a socioeconomic right helps to illuminate the values that support the implementation of those rules, as well as their social consequences. So what happens to families living below the federal poverty line who no longer have water? What do? Where do they go? Right? What is the effect of water service termination on physical and mental health, on low-income housing options, or on child welfare? In households without running water, parents are at risk of losing custody of their kids to Child Protective Services because the absence of running water constitutes physical neglect under Michigan law. All of these questions are important for understanding law's relationship to social welfare. Stepping back a bit more, we could examine how it is, as a matter of history and politics, that a $6 billion municipal water debt ends up landing on the shoulders of the city's poorest residents. Right? In what ways can bankruptcy status immunize a city from accountability to its residents? After all, there was no amount of voting or protest or litigation, no amount of global shaming that could alter that city's course at a bankruptcy. And perhaps most critically, we could examine how we became a country that cannot imagine water as a human right. Right? How can we chart a path in this country from seeing something like water, an element of life as ineffable as the air we breathe? How do we how do we move an issue like water from seeing it as a commodity to seeing it as a human right? How do we understand the task of ensuring that all of our society's members have the basic necessities of life? And critically, how do we do that in the context of a deeply institutionalized capitalist system? Right? A system that makes it difficult to even imagine making claims on any basis other than one rooted in the market. When the science fiction writer Ursula Le Guin won a Lifetime Achievement Award at the National Book Awards 2 years ago, she gave an acceptance speech about the insidious effects of the commodification of art. And Le Guin closed her speech by saying this: "We live in capitalism. Its power seems inescapable, but then so did the divine right of kings. Any human power can be resisted and changed by human beings. Resistance and change often begin in art, very often in our art, the art of words." A theory of the relationship between law and social welfare in the United States would allow us to see how our social, legal, and economic systems articulate with each other, how they reinforce each other, and in some rare cases, how they can be re-articulated to produce something new. For we too begin with the art of words. Constructing a theory of law's relationship to social welfare promises to open up whole new areas of inquiry at a time when questions of economic security and inequality have never been more pressing. Thank you. Comments?
First, thank you. It was a great presentation. On the issue of whether there is a theory, it strikes me that one thing that can happen is trying to make it scientific. Theory is an if-then proposition.
Mm-hmm.
And the proclivity to move in that direction is what political science
Mm-hmm.
is. But law is different. The legal reasoning is very different.
Mm-hmm. Right.
And it doesn't
Mhm.
side, including society.
Right.
So it strikes me that if that's the case, then what's missing is that law may be more in the field of humanities,
Mhm.
but it is in any kind of scientific,
Mhm.
and that it may be just elusive looking for the field.
Mhm.
And indeed, how we decide things is always through a political process.
Mhm. Right.
There is no optimal allocation of
Mhm.
resources. That's Keno's
Right.
possibility. So we've got to do some balancing, and
Mhm.
that's done in this stew of political
Right.
process. So is it possible, are we trying to reach for something that's
So I would agree that in the disciplines of political science and sociology in particular, there's that the academic move to science is a shift away from sort of normative prescriptions about what ought to be done in society. But in law and society and public policy both, neither field ever abandoned that commitment to sort of normative ideals. And the idea in both fields has been to deploy social science in order to help facilitate political discussions about distribution. That was the originating motive for law and society, although again that shifts away in the 1970s, and that was the motivation for public policy as a field. So it's not that these, and that's why I'm focusing on these two fields in particular, because these two fields are the areas where we would expect, if anyone was going to be studying this, it would be these two fields. And there will always be debates about, whether you can have good objective science in the presence of normative and political debate. But that's a debate that will never go away. And some fields have committed to that debate more than others. And I think both public policy and sociolegal studies have that in common. Yeah.
Thank you again. This was really described to me because I understand this a lot before sitting here. But one thing I wanted to know about is, do you know the history of how education became in America thought of as a socioeconomic right? Because to me it seems like water and housing and all these things that are like more property based, it makes more like your argument is so strong.